I'm Sarah Squires, the director of the Nurturing Coach, a specialist therapeutic service for people who have experienced narcissistic abuse, parental alienation, and the creator of the Get Court Ready program and series of resources, which are all designed to help people going through family court against a narcissist. Today, I am going to be talking to you about how to turn your story into evidence. And this is something so many people struggle with because they've usually got so much evidence that they don't know what to do with it. They don't know how to organise it. They either dump it on their solicitor and then the solicitor will miss valid points, or it'll cost you a fortune for them to go through all of it. And even then it might get diluted down. They might miss the patterns, all of that. What I've created is tools to help you do that work. To help you explain to your solicitor exactly what you're dealing with. And this workshop will help you to develop a plan on what to do with your evidence, what to do with the vast volume evidence, how to funnel it through so that you've got clear patterns, you've got evidence that this is not a one-off, this is a consistent and persistent pattern of behaviour, and this is having a huge impact on you and on the children if you're in child arrangement proceedings as well. So I hope that you enjoy the presentation. There are some free resources that I'm going to share with you as well, so let's get on with it. Your story does matter, but in family court, raw emotion isn't enough. The system doesn't speak in pain, it speaks in evidence. It's not that you're too emotional, it's just that you've never been shown how to speak the language of evidence. And that is what I want to share with you today. So for many of my clients, and I'm sure you'll resonate with this as well, they go into family court, whether that be in mediation or within the court or within CAFCAS meetings, and feel unheard, disbelieved, or even labelled. That might be parental conflict, or it could even be as being abusive. They're often overwhelmed by what to include. None of my cases ever have I felt that they didn't have enough evidence. It's usually that they've got so much evidence that they don't know how to present it. And what happens is they dump it, they deliver everything, and it ends up basically sounding like emotional instability or a bit of a rant. And what happens is when someone dumps a lot of information on you without context, without clear, definitive patterns or categories, it gets lost, it becomes diluted. And most people are unsure how to describe this type of behavior when you're dealing with a narcissist. It's emotional and psychological warfare. So how do you describe that without sounding too emotional? And these are all the things that I want to help you shift today. So the first thing to really help to reframe this is that the court doesn't ask how you feel. This is not, they don't really care about how you feel. I know that sounds harsh, but they don't. What they want to know is what has happened and what the impact has been. Now, that might be on you, but mainly if you're in child arrangement proceedings, it is on the child. What has been the impact of this behaviour on the child? So an example might be, rather than saying he makes me feel anxious or she makes me feel anxious, it would become they sent me 17 messages in 3 days, including during school pickup. So you're talking about the specific behaviour. And for anyone who's feeling a bit triggered now that your story isn't being told truthfully, because we're not saying the emotional impact that had on you, court is not the place for that. Court is you're trying to describe the behaviours and the impact. And so please know that that emotion, that anxiety is, I'm not diminishing it or belittling it. I'm just helping you to speak the language of court. I understand how and the impact of that anxiety, but what we want is we want to find ways to translate that. And I'm going to discuss that more as we go through. So these are some tips for you. So the first thing is to anchor every single claim that you make to a date or a pattern. And ideally, as soon as possible. So before you enter court, if you're filling in a C1A or just applying for court, you need to be able to be sure what you can prove with a date, the evidence, or if it needs more context, what the pattern is. So what are you saying this particular incident was in relation to a pattern of harmful behavior? Next, highlight how has this impacted either the child or the process, because a lot of their behaviors actually are what I call legal maneuvering. So they're trying to use the system to perpetuate the abuse, but also to get out of accountability. So they won't want to have fact findings. They won't want to have other professionals with more expertise involved, because they want to avoid that. What they want to do is focus on the chaos and the disorder of this, because that's where they thrive. They thrive in that environment. So what you need to show, how has this incident or behavior impacted, like I say, either the child or the process. Again, we'll look at how do we say that in more detail in a bit. So avoid labels and only describe the behavior. I know that sounds like a stuck record because you probably hear it all the time, but some of these terms have become so colloquial that we don't even know we're using them. And whilst family court is starting to recognise some of these terms, we've had gaslighting used, we've had Darvo used. Actually, in the majority of family courts, these terms are not going to be understood. And so literally describe the behavior, not the term, because Darvo, for example, or gaslighting is just a word to describe the behavior. So you've got to describe the actual behavior, not the term. So again, your emotions are valid. We just need to translate them so that they are understood legally. And patterns are powerful, because one incident might be dismissed, but a pattern is more likely to be recognised. I'm not saying in all cases, because family law is still struggling with a lot of these types of cases and the patterns as well. But this is a very simple 3-factor way of doing that, is timeline. So looking at how has this occurred over time. So we're looking for persistent and consistent occurrence of this behavior. Then what we can do is we can categorize this behavior. So this persistent behavior is called this. So that might be emotional manipulation, for example. So how many occurrences have you got? And how, again, in what the resources that I use, it's about showing the pattern of that. So, for example, they might make a false allegation every time you say no to them. So being able to prove that shows the premeditation, the more insidious and dangerous part of this pattern, rather than it being, they genuinely thought something was happening, or even just a false allegation. Is proving that this is part of their modus operandi. This is how they're trying to win, and how they're abusing the court process and you. And then finally, the impact. So whether that be on the process or on the child, exactly what it is. And again, we can look at child-focused language, because what we want to be able to say is the short, mid, and long-term impact on the child. So in the short term, they were upset because they didn't know who to use. Say for example that they turned up unannounced at an event that actually they'd been given their own time slots, but they decided to come to that one as well because they wanted to undermine you. They wanted to show how, wanted to create anxiety within you. They wanted to show how, they don't follow rules, but you can't say any of those things. So what you have to do is say, The impact on the child was they felt anxious because they weren't expecting this. We told them that they were coming on this date. Now, obviously, you use less words. I'm just describing it to you. So the mid of that is every time now, we think we've got a plan, the child ends up feeling anxious before the event because they don't know what's going to happen. And the long-term impact of that is anxiety and stress within the child, which has now become bedwetting or a refusal to go to events. So you see how it builds. So that's just one example. And like I say, we'd need to word it better, but you can see how that builds. And you can, again, going back to the timeline, you can say, and they've done this 6 times, or they do this every um, after every court hearing, when we put an agreement in place, they will immediately go against it within a week. They've already broken it, for example. So it's being able to show all of those the time, the persistent and consistent occurrence of this behaviour, the category that it fits in. So the legal category, is it emotional abuse? Is it emotional abuse of the child? Is it coercive control? Is it alienating behaviours? Whatever the legal category is, where does this persistent and consistent pattern fit? And how does that impact the child, both short, mid and long term? So this builds credibility, and it shows that intent, that modus operandi, or any escalation, so that you can prove this isn't getting better. So a bit of a legal insight, just to Justice Hayden said that key to both behaviours an appreciation of a pattern or a series of acts, the impact of which must be assessed cumulatively and rarely in isolation. So that's essentially that summary of what I've just shown you, those 3 steps in legal speak. What the advice to the judiciary is that they have to look at behaviours as part of a pattern or series of acts, and then assess each one of those patterns or series of acts cumulatively. So how is this building over time? What is that impact over time? So, for example, in the example of coercive control, one example of, they didn't let me go to my friend's party. That on its own is just an act, saying, and therefore would not fit in the coercive control legal framework. However, they wouldn't let me go to any of my friends' parties and their weddings, they wouldn't let me socialize with them. All of those things, that adds up to that series of acts and a pattern which fits in with the legal framework. And then it would be assessed as that build. So what that means, that individual act on its own, it might have been annoying at the time, one off, you might carry a grudge for a while, but ultimately, you get over it and you go to other social events, so it's done. But the cumulative impact of that is you just stop asking, so you become isolated, and that's where it fits in with the legal framework, is that isolation. So that's kind of how you prove the pattern that you're trying to get. So it's recognizing, like I say, the category. So it might be coercive control, but then it's particular behavior within that, such as isolation, and then how it is built up through that persistent and consistent behavior over time and the impact that has had. So the example I've put here is 12 messages in 4 months using your child's voice to make accusations against you. We could use that as a pattern of emotional manipulation, and that would fit under alienating behavior. So there's categories and then the subcategories. Again, I'm not going to go into that too much. This is a very broad workshop. So what we then need to do is link this all to legal language. And this is where, again, where people tend to trip up because of those colloquialisms, because of the terms that they're used to. I also find that they're so desperate. People like you and I are people pleasers. We want people to like us. So when we're dealing with Cafcass, for example, we might think that, we're getting on really well. There's a rapport here. They like me, because that's our inner childhood wound coming through, that, I really want to be liked. And so we start speaking as we would to a friend and using the colloquialisms and those really broad statements rather than sticking with the court aligned language, the link to my translating behaviours document, which goes through very specific. So, how do you take the colloquial language and turn it into court language? What shouldn't you say, and how do you reframe that? How do you structure that? So it really walks you through your experience and how to say it in court aligned language. So I'm more than happy to share that with you. These are just a few examples. And you can see it's just very professional and, like I say, more legal speak, and just try and speak like that with everyone, because if you start speaking in colloquial terms, one, either people won't understand what you mean, because people tend to think gaslighting means lying. It doesn't. That's just one part of it. Gaslighting is about that consistent pattern of undermining your reality and changing and distorting your reality, and making you question your reality. So saying gaslighting won't hit the mark. You need to find a way to say it that people that haven't experienced it and have read about it but don't really know what it means, because you don't unless you've lived it. You need to find a way to say it, and it's the same with all of these things. How do I say it in a way that someone who's never been through this is going to understand, really taking it back to layman's terms. So next step of this is use official guidance. For those of you that are self-representing, this is tough, because you didn't qualify as a lawyer. You didn't go to law school and get yourself in thousands of pounds worth of debt. Neither did I, by the way. You're just someone who either married or had kids, or had a relationship with someone and ended up in this position. So the law isn't your area of expertise, but there are ways that you can make this easier, and you do need to know the law. Not all of it, just the relevant parts. So I've put some of them down here. These are a combination of legislation and guidance, because these are some key documents that are probably going to be most relevant for your cases. Go through them with a fine tooth comb. See the language that they're using, and then structure your own statements so the court recognises it in line with what they're being taught. So you need to know, what do they know? What is their knowledge? What is their language? And then you need to match it. Like I say, don't speak in your friendly, the way that you speak in support groups and the way that people colloquially speak about this type of abuse. You need to be speaking about it in that legal context that they will understand. And again, you might not feel like it's summing up your experience, because legal terms lack the emotional impact. It fails to describe what it really feels like, and that can feel horrible. It can feel like your experience is being totally dismissed and rewritten. But this is a system that we're in, and so you need to work with what we've got. There might be times in the court process where you can have those conversations. For example, if you have a psychologist involved, they are going to understand the language of emotions more. They're not legal. They are understanding the psychology of this, and those are the people that you use that language with. But court and Kafka's the child focus. So again, the reframing it into the child focused language, you need to shift it again slightly. I talk about all of this in Court Prep Toolkit, and it feels like a lot of work, and it is. But ultimately, this is one of the biggest things you'll ever go through, and so you've got to get this bit right. Your evidence is such an important part of it, because it's your evidence that will dictate your credibility, how you present yourself. Whether you're seen as being a reliable witness will all depend on how you present your evidence. And so being able to understand what they're looking for and shifting your language to fit will massively impact. And again, even if you are represented, I still recommend knowing. Don't give all of this to your legal team, because one, they might not fully understand it themselves. But two, you need to understand from their perspective, so that every time you're speaking with your lawyer, you're not feeling that they're dismissing you. It's really helpful to understand where they're coming from, because they're not psychologists. They're not living your life. they know the law. And so you, again, it's finding that balance between your experience and the law. And this is why you've got to arm yourself with this knowledge. Know your evidence. Evidence is useless if you can't access it when it matters. So if you're stood in court, and even if you've got a barrister representing you, if your ex makes an allegation, one, you can't be jumping in and going, hang on a minute, that's not right, that never happened. What you need to do is be able to know your evidence and go, click, 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 click. Okay, that on that day that they're alleging that that thing happened, actually, this is what was happening. I was here. I was actually away on a course when they're saying I did this. Or you have the date of something that you can use in that situation. So whether it be you needing to say something or your ex saying something, know it, know the date, know the document. This helps you to be able to just pass a note to your barrister, and then they can challenge there and then on cross-examination and say, you've just alleged that this happened. Well, we've got evidence that proves that this is actually what happened. What evidence do you have? They can then cross-examine. Or if you're, like I say, if you're representing yourself, then you need to have that evidence. And this all adds to you coming across as more credible. So this is tips for organizing your evidence. Use a tracker or spreadsheet. I created the evidence tracker, which is part of the court prep toolkit, or you can buy it separately. Again, I provide links for you. And that's essentially a way for you to take all of your evidence and assess it, keep it in one place, categorize it, then go through the specific behaviors. And then there's also areas where you can organize what is DAVO? How do I evidence DAVO? Again, in language that the court's going to understand. How do I evidence alienating behaviors? How do I transfer all of this into child focused language that CAFCAS are going to understand? That is all part of evidence tracker. So then practice using your documents. Get to know exactly what evidence you have and what's your best quality evidence, because that's the other thing as well. It's understanding what is the most valuable evidence that you have and what is less valuable. Also, what needs context and what is completely and utterly objective. So what is a standalone objective piece of evidence and what is more subjective and needs telling within the pattern, because you'll have both. And you need to know the difference. So again, evidence tracker helps you do all of that, but you need to know that. So you need to know which bits of evidence are going to prove which parts of your case. And then the final bit that we're going to look at now is you've got to understand that trauma impacts your memory. And so all the things that I've talked about just over the past 20 minutes, these are all things that you need your brain to work with you. And when you've experienced narcissistic abuse, you will have complex PTSD. And what complex PTSD does is it shuts down the parts of your brain that you really, really need when you're in court. It shuts down your emotional reasoning and your logical processing. So you struggle with memory, you struggle to recall those dates. You're emotional, so you might react and you might jump in to defend yourself. These are all things that will undermine your credibility. So the next bit we're going to look at is that element. These are really important things, because all of this preparation helps you to feel more confident. And when you're confident, two things happen. One, you present better, you present more credible. And if people don't believe the story, if they don't believe the storyteller, and your ex does come across quite credible because they believe their own lies, but because of your trauma and because you haven't found the coping mechanism, or your coping mechanisms are more raw than your ex's, then you come across as less credible. And so when you work on that, you do this step-by-step process, then you become more credible, and therefore your story is more likely to be believed. And the other thing that happens with that is the more confident you present, the more dysregulated your ex presents, because they believe that they still have control over you. They are desperately trying to control you, to control the process. And when you are able to stand there completely not reacting, ambivalent to them and their games, that triggers them because they realize, oh my God, I've lost control of this person. And that triggers all of their childhood wounds around inferiority, trauma, and their transgenerational trauma, that they feel abandoned, they feel that they're not good enough, they feel that they need to do something to regain control. Otherwise, everything is going to fall apart and they're in danger. They feel like they're physically in danger. So their trauma response kicks in. And that's when you, what I call, reveal the ghost. Because the more time, you've seen horror films, that kind of thing, or a ghost film where the first person that sees the ghost, they tell someone and that person doesn't believe them because they haven't experienced it for themselves. They don't necessarily believe in that kind of thing. The next time you see the ghost, you tell them again, and you keep telling them every time you see them. The more you tell them, the more you shout at them, the more you try and make them believe, the crazier that person looks. You've seen this in films. You know how that goes. That's you. That's you trying desperately to have your story told, your story heard. When you stop telling, when they stop telling, fine, I'm going to deal with this myself. I'm not going to tell you anymore when these things happen. I'm not going to tell you when I see the ghost or see the impact. Then all of a sudden, the other person maybe sees the ghost themselves because the ghost isn't getting what they want. They want that attention, and so the person sees the ghost, and then they're like, "Oh my God, I believe you," and then everyone can work together. That's what you've got to do. You've got to stop shouting about the ghost and let the ghost reveal themselves. And that's what happens when you present as calm and credible and with clarity about what you are bringing to the table. So regulation is power. When you freeze or over explain or panic, it's not failure, it's trauma. And courts don't deal with trauma, courts deal with the law. They're trying, but what in my experience, you can't be trauma informed unless you've experienced trauma and you've gone there and you've done the work and you know your own trauma responses. You know how subtle some of those trauma responses can be. And so you're rather than waiting for the system to catch up, you need to work on that yourself. You need to work on regulating your emotions, on grounding yourself into stability, on regulating your nervous system. And again, in Corporate Toolkit, I've included all the I Am Safe tools, which are tools to help you regulate your nervous system so that you can manage in these situations. Lots of little hacks in there as well that you can do while you're in the courtroom. But again, when you do that, this all plays into that you're not reacting to your ex, and therefore they get more and more frustrated, which decreases their credibility and increases your credibility. So I just want to share this brief story with you about one of my clients. We'll call her Claire. Again, this is gender neutral, by the way, but before we worked together, she would freeze in court and she would often find herself agreeing to things that she didn't want at all, and actually that quite scared her. Once she learned how to regulate her emotions so she could listen better, so she could stay in the present rather than bouncing backwards and forwards into, oh God, I should have done this, or oh my God, what if they do that? She was able to stay and listen to what was going on. She was then able to pass her barrister a note with the contradicting evidence when her ex made a false claim against her. And as a result of that, the magistrate began to listen and the dynamic shifted. She felt powerful and present, and her ex started to feel very flustered and dysregulated, which again added to her credibility. So if you want to find out more about working with me, there's a couple of things that I recommend you do. First thing is take the false allegations. Are you prepared for court and false allegations and DAVO? That's a free assessment on the Get Court Ready website. There's also the alienating behaviours assessment, which is looking at those parenting behaviours that are there to undermine your relationship with your child. Regardless of your feelings around the term alienating, if you're dealing with a narcissistic ex and you've got children, they will be using alienation, whether they're the resident parent or non-resident parent, they will be undermining your relationship. So don't allow the word to become bigger than understanding the behaviours. And then if you want to go deeper, we've got the Court Prep Toolkit and the Master Your Evidence, which has the evidence tracker in it. Just to finish off, you're not too emotional, you're not alone, you're learning a new language and one that turns pain into power. And I'm here with you if you need me. So do get in touch. You can email me at inquiries@getcourtready.co.uk and visit the Get Court Ready website.